Dr. Dwyer.
Your Honour, might I just try to shortcut one of the issues that was raised by my learned friend Mr. Abbott, King's Counsel, I was going to deal with today in any event, which is that Mr. Rolfe, as I understand it, or his counsel, seeks the tender of 4 statements that have been recently provided to his team. One is a statement of Mr. David Koch, dated the 9th of April 2024. Then there are 2 statements of Mr. Robert Delane, dated 22 March 2024, and a further one dated 1 May 2024. And there's a statement of Mr. Carrie Joy, a former police officer, dated the 20th of May this year, which we received last Friday. With respect to the first 3 statements, that is the 1 statement of Mr. Koch and the 2 of Mr. Delane, I understand that there is no objection to those statements, and they should form part of the brief. Given there's no difficulty with them, and they don't add to the length of these proceedings.
Well, those 3 statements will be added to the brief of evidence.
Thank you. With respect to the statement of Mr. Carrie Joy, I note, regrettably, it was only provided last Friday. We have received some submissions in relation to it, or I would draw that we've received the position of some parties in relation to it. I understand the Northern Territory Police Force object to it being tendered in its entirety. NAJA has no objection up until paragraph 63 of the statement, but objects to the remainder of the statement. Your Honour, the position of counsel assisting is that the statement should be tendered, but only up until that it's only up until paragraph 63 that Your Honour should receive, and that is relevant to these proceedings, and that can be dealt with in a fair and rational way so late in the proceedings. To be clear, the information in the statement of Mr. Joy up until paragraph 63 relates to what he says is his direct knowledge of racism, including his own participation in racism in the Northern Territory Police Force when he was a serving member. In 2004, he joined the Northern Territory Police Force TRG. He left for a period of time but came back in 2008 and 2009. So obviously he was there at the time that the Nugget Award was being given out. He explains that he was the author of some awards, although he doesn't recall being the author of the Nugget Award. He accepts the possibility that he may have been an author of racist awards but can't recall them. He remained in contact with TRG members and had close friendships beyond the time that he left the TRG in 2009. He took part in training and visits to the TRG in 2010 to 2012. He expresses a view in relation to what he regards as a person who was a serving police officer at that time as genuinely racist and what is not. He says, I have no doubt heard and taken part in sharing offensive, racist, homophobic and other dark humour jokes and comments in poor taste throughout my career and life. And he expresses a view of that, including, my comments are never working with a genuine racist police officer are based on what I would feel to be an obvious fact. And he goes on to explain the difference or how he distinguishes racist language to racism. The TRG in his time, he says, was professional and was working in difficult circumstances, and he explains why he thinks that racist and offensive language is used as dark humour, as a coping mechanism. He confirms the existence of the TRG awards and explains how he thinks the Nugget Award came about. This is just by way of an example as to why these paragraphs are relevant. He notes that when he returns, this is paragraph 20, when he returned to the TRG in 2008, after a period in the AFP, the certificate and award ceremonies were still an annual event. At paragraph 28, he says, in summary, I don't consider myself racist, even though I use racist language. and explains why. And he notes that he was made aware of the existence of the award last year because the conduct was discussed amongst a lot of ex and current NT police staff who were unhappy at the treatment of Mr. Rolfe and the IRT team throughout the inquest. And as a result of that, he made the decision to contact the new Commissioner, Mr. Murphy. And shortly after that, he met with the Commissioner and another person on the 31st of August 2023 to discuss some issues with him in person, such as staff resentment and the Coronial information regarding to the incident at the Chinese restaurant and the existence of the Nougata Awards. He goes on to talk about the TRG book, the so-called red book, a red hard-bound A4 notebook with a label on it called the Book of Truths. He also explains that he, in fact, was the source of the information in relation to the piñata and the offensive use of the N-word in that regard. So he details instances of racism up until paragraph 63 and his discussion of racist things, including discussing certificates with the Commissioner in August 2023 that, in my respectful submission, appear to be of relevance and within his direct knowledge. The remainder of that statement, however, is based largely on his opinion about things that occurred when he was not a serving member of the police, where he does not have access to the full brief, and they come in on Friday before we start on Monday in circumstances where there is not time to afford all those people mentioned procedural fairness to be able to respond to them. And they are of very little relevance, that is his opinion, at this late stage in a way that would justify their late receipt. With respect to the comments that he makes about his conversation with the Commissioner and the information he divulged in August last year, I note that the Commissioner will, of course, be afforded every opportunity for procedural fairness and invited to give evidence this week about that, given that it would not take a great period of time. It's one discrete conversation, which in my respectful submission does appear to be of relevance. So I, in short, support the position put forward by Mr. Bolton of Senior Counsel on behalf of NAJA that Your Honour should receive that statement, but only up to paragraph 63.
Yes.
May I please, Your Honour, we, on behalf of the Northern Territory Police Force, have a different perspective. Mr. Joy is not an interested party. He's not even been a witness. He has previously, in the course of preparation for this inquest by a statutory declaration for August 2022, volunteered gratuitous opinions and extensive accounts of matters. We invite Your Honour to conclude that he is a disgruntled former member, a self-appointed activist who wishes to promote the cause of Zachary Rolfe. Not only that, but his perspectives, for what little they're worth, are extremely dated. He tells Your Honour in paragraph 5 of his statement that he took himself on long service leave and work outside the Northern Territory Police Force between 2013 and 2016, and then he resigned in 2016. So what you have is a person who has a range of positions that he's been enthusiastic to ventilate through sympathetic media, arising from his experience in the police force, which now dates back in excess of a decade. I described him as disgruntled. You know from paragraphs 86 to 87 that he's been keen, in spite of his disgruntlement, to resume a position in the Northern Territory Police Force. He has not been welcomed back for a variety of reasons. It appears that he remains aggrieved about that and perhaps still wanting to resume a position in the Northern Territory Police Force and to do and say whatever will assist him in that regard. Now, as to the material in this statement, I'll confine our remarks to what precedes paragraph 63. But what Your Honour can identify is that the hearsay to which our learned friend Dr. Dwyer referred is not confined to the paragraphs after paragraph 63. You can see it in paragraphs 38 and 52 and 57 as well. And in respect of 57, you can see that he refers to a conversation he says he had with a politician who referred to a senior member of the police force. It's information of minimal probative value. It's at least second-hand hearsay, and it seems to be the kind of insinuation and innuendo which Mr. Joy wishes to peddle to this court. What we submit to Your Honour is that that should not be indulged by a person who is a busybody. He's a former member of the police force. He has some recollections, no doubt fading with the passage of in excess of a decade. He's taken himself to ICAC and given them quite a deal of information about a variety of matters, and he's keen to reiterate what he's told ICAC at paragraphs 50 and following. Your Honour might conclude that what he's told ICAC should remain between him and ICAC until ICAC chooses for that to be otherwise. In essence, we respectfully submit that on an examination of the material in those first 63 paragraphs, it is more than apparent that our description of him as a disgruntled former member is accurate. There is nothing fresh, nothing which really adds to what has been provided to Your Honour from more reliable sources, and mostly has been able to be the subject of cross-examination. We do certainly not propose that he be brought here to give evidence, give him the pedestal which he appears to have been yearning for many years now. Whatever information he does have is extremely dated, and it's jaundiced from a desire to be an advocate for Mr. Rolfe. We urge upon Your Honour not to set an unfortunate precedent by encouraging a person who wants to assume a position of importance and apparent informativeness, who has not been identified by Your Honour as worthy to be a witness or an interested party, but nonetheless wants gratuitously to express his opinions to this court. In our respectful submission, you should not receive the statement. It will not advance your capacity to evaluate the important issues in this inquest.
Mr. Bolt.
In support of the application to include paragraphs from this statement, I submit that although it's just one more police officer's or ex-police officer's evidence about issues that touch upon racism in the Northern Territory Police, and in particular the TRG and Supervisor Jonathan in Alice Springs, it does provide some further insight into the way things might be found to have occurred. Just by way of obvious background, racist attitudes in the cohort that were involved in the tactical operation that led to Kumanjayi's death is on the list of issues for determination at the inquest. NARJA has consistently been testing evidence about these attitudes throughout the inquest. So it was, not because of NARJA, but Your Honour accepted a large body of material that related to Mr. Rolfe's attitudes. When he eventually gave his evidence in court last time, he decided that he would give his version of who else was involved in this sort of racist language and conduct. The immediate response of the Northern Territory Police was to have the Commissioner of Police stand up in public the next day and essentially to deny that there were any such attitudes. Never seen it in my travels around the Northern Territory. There might be the odd single or uncharacteristic officer, but that's not the way things operate in the Northern Territory. The next day, my learned friend, Dr. Freckleton, organised for a range of statements to be introduced into evidence in this inquest, including from an acting Assistant Commissioner of Police, a Superintendent of Police, and the Divisional Superintendent of Police and Senior Sergeant, all of whom had close connections with the TRG. And their evidence has been accepted. If their evidence is true, what Mr. Rolfe says is false, what Mr. Bowen said in his evidence is false, NAJO will not be submitting that those aspects of Bowen's evidence and Rolfe's evidence about the TRG awards is false. But there will be a concerted effort by the police to suggest that it's just the odd one or two bad apples who have held these views. Irrespective of Mr. Joy's motives and irrespective of his of the legitimate criticisms that Dr. Freckleton made about him just now, there is a degree of force in what he has to say in the first 63 paragraphs of this statement. They are against interest. They are contrary to the position that the police are going to present in their submissions. It is another view of the way in which police speak about Aboriginal people in the Northern Territory, including in Alice Springs and including in the cohort, which is the subject of this inquest. I don't require Mr. Joy to give evidence on oath. I don't require this inquest to be prolonged because of his very late-breaking statement. But in my respectful submission, there is some real probative force in what he has to say about the issues that Dr. Dwyer just mentioned in her submissions. Maybe there are some paragraphs in that first 63 that are unfair, and I would accept, for instance, that Mr. Joy's reference to the Northern Territory politician, which is in one sense scandalous and without any other form of proof, that might not be accepted, maybe carved out entirely. No one, I'm sure, is going to put any weight in it, and it doesn't touch upon the issues in any event. But otherwise, by the time you get to paragraph 63, the end of paragraph 63, there's a picture that has been painted of police who accept that it's fine to talk in a racist way in private, but that it has no impact on the way that they carry out their public duties as police officers. That's exactly what we've just heard from Mr. Bowens. It's exactly what we heard from Mr. Rolfe. and there's a growing body of evidence that that's a very common approach to racism in the Northern Territory Police Force. And I'd urge Your Honour to admit at least paragraphs 1 to 63, as I say, perhaps to exclude paragraph 57.
Does anyone else wish to, I'm just checking if there's anyone else before you, just in case, Mr. Abbott. Yes, I've got.
Okay. Your Honour,
Thank you.
we would adopt the submissions of Mr. Bolton, particularly noting the fact of the way that the distinction was developed in recent times from some witnesses as to the perception of the difference between persistent racial language on the one hand and the question of whether at all that affects conduct. So that's an issue that is of real significance. It's clear that some of the parties are arguing that in truth, persistent racist language does indeed affect conduct of the attitudes of people, and so to the extent that the statement can be given any weight, in our submission it wouldn't be given much weight for the reasons that were even articulated. It can be of some use, and we've also agreed, merging both the submissions of Mr. Dr. Freckleton and Mr. Bolton, that even within the first 63 paragraphs, there may well be some paragraphs which are just so outrageous, and so that are so outrageous they can just be struck out. If you want, please.
The Brown family take the same position as the Pumperoo Committee and Naja. Thank you, Your Honour.
We urge and seek the entirety of the statement be accepted. But in particular, if I'm forced to make choices about what parts, other than the first 63 paragraphs, I rely upon paragraphs 106 through to, I think it is, 121, which deal with this witness's view of some of the events that happened on the 9th of November 2019. With respect to my learned friends, are prepared to accept the parts of this statement that suit their cause, namely those parts that deal with racism in the Northern Territory Police, but they won't accept this witness's statement in relation to some of the very pungent and correct criticisms he makes of the way what he refers to in paragraph 106 as the tactical operation. And the flavour of what occurs between paragraphs 106 through to 120, he starts off by saying, as a previous tactical operator, it's also simply ludicrous to suggest it's also okay to send staff into a high-risk area, high-risk event, but say I'm only deploying you as low-risk response team, therefore I'm not seeking correct approvals, providing you with any approved plans. And he goes on to say why that's ludicrous. This is all relevant information and proper comments and statements from a police officer, a former police officer, who, as he says, has the qualifications of a previous tactical operator and who knows and can comment accurately on the way in which the police handled the events of November 2019. So I ask, if I'm forced to choose parts of this other than the first 63 paragraphs, I ask that in particular paragraphs 106 through to 121, and I won't read them out because Your Honour can see them, but they all deal with the lack of planning, the lack of risk management, what he refers to as the fake medical escort to the airstrip, and he concludes paragraph 120 by saying everyone involved with this Coronial needs to understand Rolf wasn't at a barbecue with racist friends who just decided to drive 300 kilometres out of Alice Springs and shoot someone. They were off duty, called in by their supervisors and deployed by them to a remote community. Nothing about this incident has anything to do with race, religion or gender. And he goes on to say why that is so. In my respectful submission, these statements are relevant and should be taken into account.
Dr. Friggleton?
Very briefly, then, Your Honour, in respect of paragraphs 16 and 21, we respectfully submit that those constitute a commentary that is clearly intended to promote the cause of Mr. Rolfe. From a person who is not an expert, though he would appoint himself as such, he does not have an informed perspective in any kind of a contemporary sense. He not having been in a relevant role since 2013, and in our submission, those paragraphs are argumentative and tendentious and unlikely to assist Your Honour in any material way. Mr. Joy not being privy to a large amount of information that Your Honour does know about and has heard over many days of the inquest. His attempt to provide these opinions to you falls into the same category as the evidence which Sergeant Bowens through Mr. Sumner attempted to provide to you. There's no prospect of assisting you. We adhere to our submissions generally, but we do acknowledge with appreciation the observations made by Mr. Bolton in respect of paragraph 57, and ask that should Your Honour permit some part of this statement to be received, which we urge against, that not include paragraph 57. We also note that there's some reference to attachments in the statement. We don't have any, but should there be any, we should like to be heard in relation to any of those being received in those circumstances.
Your Honour, can I just say for the record, the Walker Lane and Robertson families adopt Nigel's submissions.
Thank you.
Just briefly, there are attachments. I think that was just an oversight that they weren't sent around. They can be sent around at lunch, but it's my submission as counsel assisting that they should not be received and don't assist, Your Honour. In relation to paragraphs 106 to 121, they make the very point that I had put forward earlier, which is they are bare opinion, presented very late and in circumstances where Mr. Joy does not have all the relevant evidence. That is very different to the evidence that he gives about a direct conversation that he had with the current Commissioner of Police on the 30th and another person on the 31st of August 2023 to discuss certain issues, including the NUGDA awards. And he goes on to say that he gave the Commissioner of Police certain advice, including that he should make contact with Senior Sergeant Gill to get the background and deal with the issue in the case if it was to be raised in the inquest, and that Mr. Murphy inquired what form the awards were and he clarified the form of the awards, that's paragraph 33, as A4 certificates, etc., including one he had actually seen with the actual Aboriginal flag. He also informed Mr. Murphy that potentially 100 odd people may have certificate copies, pictures of them, videos of presentation, evidence of the NUGDA Club, etc. So he's referring to a direct conversation that he had with Mr. Murphy at that time. It's in stark contrast to the remainder of the statement. I respectfully support what's previously been said about paragraph 57 and suggest that there's no need. Is at no relevance to Your Honour, that paragraph, and I would press for that to be received.
Thank you. Are there any other issues that you wish to raise, Mr. Abbott?
Your Honour, I mentioned the two other issues that I wanted to raise, and I take it that I need not elaborate on because the statements issue has been resolved,
Yes.
other than this part of Mr. Joy's statement.
Yes.
And the only other issue that I wanted to raise was our opposition to Naja's submissions. Does Your
Yes,
Honour
and
wish
I'll
to hear
deal
from
with
me
that
that?
now.
Very well.
I'll hear it now and then I'll be taking lunch.
Yes, thank you, Your Honour. I should add, I did make an application to seek the TRG members who've given the statements should be called, but I don't wish to enlarge upon that issue any further.
Your Honour, just in relation to that, can I deal with that in brief measure? No such application was made to the council assisting team before today, and that is so there should be no misunderstanding in relation to that. Mr. Officer has no difficulty calling me, and we have a cordial relationship where we can discuss any matters at any time that is appropriate. Mr. Abbott hasn't sought to contact me, but there are lines of communication that are open and have been urged upon all of the legal teams, including Mr. Rolfe's team. There are emails that are regularly sent between members of the legal team, copying in everybody so that any issues can be raised beforehand. It's simply not appropriate for these issues to be raised so late in circumstances where we are doing absolutely everything possible to manage this inquest sensibly and to finish this week.
If there is any such application pressed, it can be pressed in writing and it can be dealt with at an appropriate time, but it won't be dealt with during the course of these sittings where we have full time allocated to witnesses. But I will certainly, if there is to
Mr. Officer will deal with that.
Thank you.
Thank you. Could I now have my 5 minutes in relation
Yes, you
to
can, Mr. Abbott.
Naja's written submissions? Do you want to have those submissions in front of you or on a screen?
I don't have them in front of me or on the screen. I have received them.
Right. Well, Your Honour,
I can, I no doubt someone can provide me with a screen.
I've got a copy here. Okay.
Your Honour will see that in 4.1,
Yes.
Paragraph 3, Naja now makes a formal application to the court seeking production of the notes.
Yes.
I point out that that's a very late application made last night. And on that basis, they say, Naja says, at 4.1 that they have a live interest, and that live interest is set out, as I discern it, at paragraph 6, where they say and speculate that the balance of the notes, highly likely, they say, the balance of the notes contain Mr. Rolfe's opinions about matters of relevance to the inquest. There's no evidence of that. And they say including one or more of the issues on the issues list in this inquest. I haven't seen the issues list, but I understood that it was supplanted by Your Honour's ruling number 2, perhaps number 3 I'm thinking of, but I know that I've seen a list of Your Honour's issues in one of your rulings. But in any event, they say 6.3, it's possible the notes contain information in relation to at least the following: Mr. Rolfe's musings about the interrelationship between the former police commissioner and the executive government, including the former chief minister of the Northern Territory. Well, I'm not sure what possible relevance that would have, assuming that the notes contained those musings, and what Your Honour would do with those musings if you receive them. But they conclude in paragraph 7, because this is the live interest issue, by saying, because the notes are representations made by the person who killed Kumanjayi Walker, they are likely to have material weight in the proceedings. All I can say to my learned friend, be careful what you wish for if these are to go in, because, Your Honour,
There's no
I say...
suggestion that they're going in anywhere at the moment, and that's not the application, Mr.
No, I know that, but the issue is that they should be produced to him, and the basis of that is because some so-called live interest, which I say they have no live interest whatsoever, and we've said so in our outline. And they give other reasons, the next one being production of the notes to Naja does not prejudice Mr. Rolfe. They say that we've been, in paragraph 11.2, that we have been aware of Naja's intention to seek the notes since at least the 22nd of March 2024. Well, we haven't been aware of their intention to seek the notes. since they filed their submissions. As we said in our written submissions, we proceeded on the basis that there's one application and one application only has been made in respect of the production of these notes, and that is the application that my learned friend Dr. Freckleton has made for these notes. And on that basis, as we said in our written outline, we considered the legal situation and we decided that we would not do anything in opposition to that application. However, that I now find is being used against us, because at paragraph 15 of the Najar submissions, the bootstraps argument is ventilated that until the date of the filing of these submissions, Mr. Rolfe has made no argument that ruling number 10 was plainly wrong. Any argument in relation to a lost appeal opportunities without merit, that's just incorrect. It's insofar as the inference being that we have no argument in relation to ruling number 10, and that we have no merit to any submissions we might make. And then the argument is put, Najar having access to the notes will not be any more or less contrary to Mr. Rolfe's interests than the Northern Territory Police Force's possession of the notes. Well, we say, Your Honour, that we have grave concerns about that, because what's happened in this inquest is that matters have a habit of finding their way to newspapers and social media. I make no criticism or allegation in relation to my learned friend Mr. Bolton, but the fact of the matter is the wider dissemination that any document has in this inquest, the greater the chance of that document being improperly distributed by persons who happen to come in possession of it or are aware of its contents. And the final argument, which I must say I can't understand, is a claim that Your Honour was guilty of infringing the slip rule when you made the order allowing the learned friend Mr. Freckleton's client to have production of the notes. We say this argument on paragraphs 18 to 20 is just inappropriate, and that the submissions that are made that somehow Your Honour proceeded upon an incorrect basis, and that what Your Honour did in making your written ruling number 10 was an example of the slip rule applying in our submission is totally without merit. And so, Your Honour, we say that for those reasons and for the reasons which we set out in our written submissions, the production should only be to Dr. Freckleton's client.
Might I just very briefly, and I don't wish to reply to everything said, make 2 points. It's not just Najar that's applied for those notes. It's also the Walker Lane Robertson family, the Brown family, the Paramparoo Committee, and the Northern Territory Police Association who has applied for access to those notes.
I wasn't aware. I haven't seen those. Anyway, I accept
that's in the emails that have been circulated to all the parties.
Well, not to me.
Yes, there's that issue. And what I would propose, Your Honour, with respect, is that if Your Honour is to grant other parties access, then Your Honour would also make a non-publication order over those notes pursuant to Section 43 of the Coroners Act, and that non-publication order would be in similar terms to other orders, and would read something like this, that subject to orders 2, 3 and 4, I'm going on the basis of other orders that Your Honour has made, subject to orders 2, 3 and 4, there be no disclosure or other publication of the 10 pages that Mr. Rolfe read from or took into evidence. That doesn't prevent, however, the disclosure of the contents of the brief to parties granted leave to appear for the purpose of these coronial proceedings. And it doesn't prevent the disclosure or publication of any evidence given in open court during this inquest, any documents, audio-visual or audio material that's tendered, or any material made publicly available, so that the exclusion from that is relevant questions that are asked of any witness in relation to material within those 10 pages. And this is only if Your Honour makes the determination, of course, that the remaining 7 of the 10 should be provided. It would also, consistent with standard procedures, say that Order 1 does not prevent the Northern Territory Police Force from using or disclosing the material for the purposes of performing its statutory functions and doesn't prevent disclosure where required by law to any other statutory entity for the purpose of disclosing the function. So I can formalise that in writing, Your Honour, but consistent with other non-publication orders that Your Honour has made, it can be dealt with via a non-publication order, and that might alleviate some of Mr Abbott's concerns. So there's only relevant questions based on that documentation that become part of the evidence.
Thank you.
As Your Honour knows, we have applied for non-publication order in respect of the contents of the notes. We refer to and repeat our submissions in that regard. We are content with the formulation as broadly proposed by Senior Counsel assisting. We reserve our position in relation to whether a non-publication order in respect to particular evidence that ends up being given as a result of cross-examination is necessary to go ahead.
Yes, thank you.
Yeah.
Yes.
I'm not going to repeat what we put in writing, but the nub of it is just because of the way things fell out last time and in the interim, the focus was really just on the police having the documents because it was my learned friend called for the 7 remaining pages.
Yes.
There's no property in those documents that specifically relates to the Northern Territory Police, nor should there be. Everybody else has much the same forensic interest in them. And Naja was the one that was ventilating the reasons, was ventilating actively the reasons why the claim for legal professional privilege was misguided. And we said there was no legal professional privilege, and that's what Your Honour ruled. Could not have passed anybody's notice that we're interested in getting copies of them in light of the arguments that we advanced. We're happy with the proposed non-publication orders. They've worked throughout the course of this inquest. The suggestion that somehow or other there's been a danger attaching to the distribution of documents that have been misused by people associated with parties is baseless and, in Naja's case, totally untrue.
We will adjourn for a return.
All stand across the board.
She said that.
Yeah.